It's my absolute pleasure to introduce our first speaker to kick off Daughterhood San Diego's 5th anniversary. That speaker is Amy Hsiao, and she is the founding attorney of Hsiao Law, which is a boutique law firm here in San Diego focused specifically on estate planning, on disability and elder law. I know Amy very well. She is incredibly sharp, skilled, and a compassionate attorney. She works with multiple generations in a family to ensure that their wishes are honored with dignity and quality, and all while keeping as much assets as possible within the family. So for all of those reasons, it is why I actually chose Amy to handle my own estate plan for my own family. So I have firsthand experience with Amy, and I know that our Daughterhood community is going to get a lot of value out of her presentation tonight. And not just a lot of value, but also likely a lot of questions too. So, typically legal topics tend to they tend to spark a lot of questions. So if you have any that come up during Amy's presentation, just write them in the chat. And after she's done presenting, I'm going to moderate them, and Amy can answer any of the questions that come up in the chat box one by one. And hopefully they're more general questions that everybody in the group can benefit from. If you have anything specific for your particular situation coming up with your family, then Amy's going to give us her contact information, and you can get in touch with her directly. So with that being said, it's my pleasure to introduce you to Amy, and I'll let her take it away.
Hi, thank you all so much. Thank you, Christine and Karen. And honestly, I have to say, I got a little teary-eyed as well when I was watching the video. It's just so touching. I remember the time when I first met you. You were going through those things that you were just mentioning in the video. So I'm just so happy and so honored to be able to present today. And I know I only have 45 minutes. And I see just now, we have audience from every state, like a lot of different places in the country. So I'm going to focus my presentation, and I'll give you tips that are more general so that you can take it and use it and apply it to wherever you are at. But then I'll throw in some specifics to California. And of course, as Christine said, if you have any specific questions, I'll make sure that you get my contact info, and then we can talk privately about your specific situation. So with that, I'm going to share my screen here. Let me just do this, share screen, and then let's start from the beginning. Let's see. Can you see my my PowerPoint? Yeah? Okay. All right, great. So let's go ahead and get started. So the topic today is top 10 rules for getting your parents aging ready. Now, just a little bit about myself. As Christine said, I've been doing estate planning for a while now, and I started my own boutique law firm more than 5 years ago. I've been practicing for almost 10 years now. And I started out as an estate planning attorney, but the more work I do on this path, the more I see the need for elder law. And we'll get into what that means in a little bit, and more for incapacity planning. And, being a caregiver myself, I really see that need, and I'm just really passionate about this area. And I can't wait to share with you all that that I have, and within the limited 45 minutes. So here we go. Really big picture. You're not attending this legal webinar for fun. You're here for love. I mean, who wants to attend a legal webinar for fun, right? So I honor you for that. And thank you so much for taking the time to be here with me in the next 45 minutes. We'll get into a little bit of jargons here and there, but I promise you, the information that you learn within the next 45 minutes are going to be so valuable. It'll really make your life much easier as a caregiver. And so the big picture is, what are some of your choices, and what do you want? What do you want out of all of this? Why are you even here? Really, we want to know, because I know there's so many moving parts involved in taking care of somebody. Right? And how can we find the resources? How can we get the guidance? How can we know that we can rest assured and know mom and dad will be well taken care of? Now, who are you here for, right? Is it your mom? Is it your dad? And, what sort of needs what kind of needs do they need, or what are you doing for them, right? And so how can you make sure that they are well taken care of, they have the resources available? And so I want to kind of highlight some items, and I have 10 rules specifically carved out on how to get your parents aging ready. And now, before we get into that, I do want to kind of give you some preliminary items of this overall legal and life planning, legacy planning, right? Do your parents even have any type of plan? Do you know what that is? Do they have any, like a will or a trust or anything like that? Do you know what that is? Do they have anything in writing? If so, where is their plan? When was the last time they reviewed their plan? Is it updated? Do you know where it is? Do you know how to access it if an emergency situation comes up? Now, I want to make a distinction, and it's very, very important as caregivers to be able to make the best decisions, sort of do right by mom and dad, right? There are many different attorneys out there, and you want to be able to distinguish the types of attorneys that are good for mom and dad. And so the traditional estate planning is planning for death, right? It only occurs after somebody is gone. But we all know as caregivers, so much of it is that taking care of them period of time. And in fact, sometimes, the it's so much of it, like if they have to, we need to make sure they're good at home, and so there's actually a huge component of that, like the incapacity component, not just planning for death, not just planning for that, but also planning for, so what do we do when mom and dad starts losing capacity? They're kind of forgetting things, or depending on which stage you're at, and there's just many complications to that. But so we want to really think about how can we kind of shift the perspective a little bit and not think of estate planning as simply planning for death, but more like how can we plan for mom and dad to have the best quality of life and to preserve as much dignity as possible. And how can we go about doing that easily and reduce as much stress as possible? And what I'm about to share is really a lot about preventative lawyering, right? The more you can prepare mom and dad and the more you can get those documents in line, the less stressful it'll be for you. I've done some deathbed planning, and trust me, you do not want to be in that position. And so there you go. So here, to just get it out of the way, if you don't already know, long-term care is extremely expensive. If your mom and dad, if parents need long-term care, the average private pay for a nursing home here in California is $10,000. And in other states, it's easily around this number, and you can easily find out the number, online, but it's very, very expensive. And average, if average, I would say 4,000 to about like 20,000. It's just insane. Very rarely do people have that kind of money to pay for long-term care every month. And very quickly, you'll find you are in a situation where you're super stressed out. Like, how am I going to support my mom and dad? Like, mom and dad, like, what money do they have? Like, am I going to quit my job and support them? Then what about, like, where do I get the money, right? So there are 3 pots of money that you can use to pay for care of mom and dad. One is your own money, or mom and dad's own money. Second is long-term care insurance, if you're lucky enough to have plan for that in advance, or you can still try to qualify for one if it's not too crazy expensive. And then government benefits, sorry, there's one T typo. But so there are 3 pots of money. Now, with your own money, as we can already know, or if you don't already know, the money goes away very quickly. And oftentimes, and for long-term, even if you were trying to apply for a government benefit, then you look online, you're like, what? Like Medi-Cal requires, or Medicaid requires me pretty much to be impoverished to be able to get government benefit. So, I don't want to just solely be dependent on the government, because what if I can't qualify? Right? And so the system is just so bizarre. It protects the people who are either extremely poor, or you have to be so wealthy that you just pay for everything on your own, right? So how can we plan around that? And so one segment of estate planning is called elder law. And elder law, the whole purpose of elder law planning is to avoid impoverishment and to allow for greater access to quality care. So we as attorneys, we are able to utilize our knowledge and the rules of the laws that's laid out in the Medicaid manual, and every state has its own Medicaid manual. And I am licensed in California, but and later on I'll give you general guidelines, but if you have specific questions that's specific to the state, I will be happy. And I do belong to NALA, National Association of Elder Law Attorneys, and we have a group of attorneys around the country who I'm happy to refer you to, and I know their work product, so I'll definitely put you in good hands if you're not in California. Of course, in California I can just give you the answer. And so moving along, with that, let's get into the 10 rules for you. First one is, of course, talk to your parents about long-term care and their future. This seems so intuitive, but it's actually really hard. As a daughter, I know it's one of those things where how do you even plan for your parents if they're not willing to talk to you about it, right? Of course, depending on where they are at and depending on how open they are. Rule number one is really to somehow, and of course you can get the support from daughterhood of how to talk to your parents about it, but the most important thing we want to make sure you talk to them about as from the legal perspective is where they want to, where they wish to live, how to pay for their care, what health care they wish to be provided if they are ever in a terminal, vegetative or end stage type of situation. So you want to get into these discussions so their wishes and desires if you ever have to make decisions for them. And I'll get into all the healthcare document in a little bit, but the first step is to be able to talk to them about it, right? Like what would they like you to do for them if they can no longer make decisions on their own. Any insurance that you need to know about, important papers and how do you access them. And you want, one thing that's really important, at least for my parents, is you want to explain to them, hey, I'm not trying to meddle with anything here, but I care a lot about you, and I want to make sure that you get the care that you need at the time when you cannot make the decisions yourself, right? And you can even share with them, I'll share with you what probate looks like. You can share with them, tell them, if you don't do this, if you don't talk about this with me, this is how much you're going to cost the family. So I'll get into that a little bit. But the first step is get them to talk to you, whatever strategy you want to use. Number two is, here we go, the legal component. The very first legal document you want to absolutely make sure they have in place is the power of attorney. And with mom and dad, if they're starting to, forget things, losing capacity, you want to make sure they have a durable power of attorney with special provisions that includes long-term care that allows you the specific powers that you can take or not take to take care of, to either apply for government benefits or, things like that. And don't worry, I will put these in writing. I'll send Christine the PDF, and so you'll have this in a PDF file. But right now, I just want to tell you, the power of attorney is the single most powerful document that's known to law. Really, there's no other document that allows another person to be able to access their bank accounts, their financial account, sell property for them, process their real estate for them, or defend a lawsuit, or even create a living trust for them. So the power of attorney is a very powerful document. If it's in the wrong hands, it's a license to steal. But if it's in the right hands, it offers great protection, and it allows somebody to step in, and it's a golden ticket for you to talk to the bank, to take care of things for mom and dad, and talk to the hospital to take care of things for them. And in fact, this just happened to a dear friend of mine who, something just happened to her dad, like last minute, her dad just had a heart attack, like just last month. And Thankfully, they had the, power of attorney in place, and she actually had her dad's power of attorney on her phone. So she was able to immediately, look on her phone and then fly over. Her dad lives in Portland. So she's able to fly. My friend is in Nevada, so she's able to fly from Nevada over to Portland overnight and talk to the hospitals and talk to the, the bankers and get everything sorted with the power of attorney that her dad prepared. So think of this as your golden ticket. It's absolutely crucial that you have mom and dad sign this. The thing is, they can only sign this document when they have capacity. Now, capacity is a very fluid thing. You can have capacity for an hour, but not for the rest of the day, right? So it's not an either or, and sometimes when lawyers, when we're trying to get the parents or, people to sign the documents, we want to make sure they have capacity. We're like, okay, when are you the sharpest, right? We ask the children, okay, so maybe mom and dad, they're usually the sharpest at 10 o'clock. Okay, so that's schedule that time to have them sign, right? And so that's fine, actually. So you want to make sure when they have capacity to make sure to have this document signed. So, and name you, right? If you're the one taking care of things for them, you want to be appointed as the agent. Agent just means the person who's able to step into mom and dad's shoes and take care of things for them. This is so important, and it has to be done right. I can't tell you how many power of attorney documents that I've seen that are just not valid. They are either not notarized or they're not. So they're like the date of the witness and the date of the person signing is different. There's just so many different reasons why they could go wrong. So here are some important reminders for you, and you may want to take notes on this. So you, as the power of attorney is something, so if mom is the person granting you, the daughter, to have the power to make decisions for them, so you're the agent. As the agent, you have the fiduciary duty to honor mom and dad's wishes. Mom and dad can then write down on the power of attorney what specific powers they want you to have, right? So if mom and dad is being reluctant and they're like, I don't want to sign my life away, like, no, like there's a trust issue or like a loss of control and authority issue there, then you can assure them and say, hey, mom and dad, this power of attorney, you can actually revoke it anytime during life. And there are also strict civil and criminal penalties if people start doing, take it, to start steal money or whatnot. So there are penalties associated if they're not doing the right thing. And they can limit the authority, right? So if mom and dad only wants you to, refinance the house or sell the house or whatnot, then they can limit the power of attorney to just that property. And here's the thing. It's way better for mom and dad to pick somebody on their own than to wait for the court to appoint somebody for them. And here's the consequence of them not having a power of attorney, right? So tell your mom and dad, okay, look, okay, great. I mean, you don't want to sign your life away. Here's the thing. If you don't have a power of attorney in place, what's going to happen is if something happened to you, you cannot make decisions for you. My hands are tied. I am not allowed to do anything for you. I cannot take care of, nobody will talk to me. Nobody will allow me to talk to them. They will ask me to go to court and file what's called a conservatorship in California, or it's called a guardianship in most states, but in California it's called conservatorship. What that is it's basically a court process, right? You have to go to court for it. If I don't have the power of attorney for my mom, then if mom goes to the hospital, and the hospital would not talk to me, or the banks would not talk to me, they want me to go to court and they want to see a court order that appoints me as the conservator or the guardian. Do you know how long it takes to get that court order? It takes minimum 12 to 16 months. It takes a year.
Can you imagine that? Like if you're in a situation where you're like, I have to talk to, you know, the bank or the hospital right now, and they're telling you to go to the court, and you have to wait like 12 months to get that court order. Mom and dad, meanwhile, is in the hospital, whatever, like what they're doing to her, like you can't even, you just don't have that legal authority. And so we really don't want that to happen to you. And I've, you know, part of my practice is guardianship, is conservatorship. And we did just one, we finally, it took us like 2-3 years to finally complete this guardianship. The families ended up spending $20,000 in court. And this can all be easily taken care of with the power of attorney. And all it takes is some pre-planning and the legal knowledge to know to do that. And the fact that you are here, you already have that knowledge. So I'm giving it to you. So what do you need to include in your power of attorney? And here's the thing, I cannot stress enough. You can get a whatever legal Zoom, you know, Susie Ono, whatever power of attorney you want, right? But oftentimes they're not going to work the way you want it to be because specific provisions are not included. And so what are the provisions that need to be included? Here you go. In the specific situation of taking care of mom and dad if they lose capacity, you want to have specific language authorizing the agent, you, to protect their income and assets against any cost of long-term care. So if you ever have to put them, you know, in an assisted living facility or like a community care, or like hire somebody to care for them at home, you want to be able to have the resources to do that. You want to still be able to try and qualify for and get that extra pot of money, if you will. And so you want to have that power to protect that asset and income. You want to have the ability to apply for government benefits on their behalf. And you want to, if you have any real estate, you want to include the legal description of the real estate in the power of attorney. You want also to be able to create irrevocable trust. It has to be specifically spelled out in the power of attorney. And one thing you need to know about power of attorney is that the specific powers have to be spelled out specifically. Otherwise, it's just not going to work. Because, you know, the realtors are going to tell you, oh, or the county recorder's office are going to tell you, oh, I don't see this power. You have to go to court. That's what's going to happen. So that's why a well-tailored and customized power of attorney is so important. And one other thing is you want to be able to sign admissions agreements on their behalf for life care facilities, right? As daughters, right? And you don't want to be contingent upon you being liable for all of their payments, right? So there needs to be certain like liability provisions in the power of attorney document. And then you want to apply for, of course, health, long-term care, insurance benefits, and make claims, if you will. And then, of course, apply for government benefits. Now, let me see if I'm missing anything here. I'm just looking at my notes here. And it is not a avoidance to conservatorship, I have to say. So power of attorney is a very powerful tool, but it's way better to have one than not. And you want to make sure it's as tailored and as customized as possible for your mom, you know, for mom and dad. Now, it's not a magic pill. We have had situations where people have the power of attorney in place, but they still end up in conservatorship and they still end up in guardianship. And that's, I mean, I won't go into all the details of why, and that's a little, you know, but to give you just one example is sometimes, you know, people name powers of attorneys, and then, you know, sister and brother, right? They're both co-power of attorney for mom and dad, but then brother for some reason is not able to sign. Maybe brother is out of country or something, out of state or something, you know, anything could come up. So, but it's better than nothing. So with everything that I've just mentioned, you know, those are good questions that you can ask an attorney when you are, you know, interviewing attorneys, whichever state you are in. You can say, hey, I learned this in a workshop, you know, do you include this in your plan? You know, or even you don't have to tell them, you can just, you know, use it as a interview, kind of test whether this attorney is a, you know, is a good attorney or not, right? Now, Another thing is you want to make sure your power of attorney really works when you need it. And here's the thing, plus a trusted relationship your family can rely on. As we all know, taking care of mom and dad, it's a battle, like a long-term battle. It's not just a one day, one time thing. And if you haven't watched the movie, The Guardians, it's filmed in Nevada. You can watch it if you want. Just kind of, get some ideas. But what I would emphasize on is you want a team of trusted advisors there for you. So you can just call them anytime with any questions. They become your personal family lawyer type of thing, right? Like you have a personal family doctor, personal family advisor that you can turn to. You don't want to work with somebody that's just like transactional, like that, bills you every time when you call them, like it's a one-time thing. You want an advisor, right? Who can really be not looking at, selling you this expensive trust or whatnot, but really looking at, okay, what's best for mom and dad? What can you do across the generations so you can capture as much wealth as possible? Sometimes there could be a conflict, right? Mom, if mom spends this much on that, then that reduces the assets for the family. So there's a lot of issues that are involved. So now, rule number 3 is get a detailed written directions about end-of-life decision making. And the picture here is writing, right? So the most important thing is you want to document it. And you can talk all you want and all about mom and dad's wishes, but if you don't put it in writing, it's as if you have nothing. And I'm a lawyer. I can't tell you how important it is to put things in writing. And so here are the key points when you're thinking about, helping mom and dad capture their healthcare wishes. And one reminder, you can easily Google like living will forms. Those, if it's just 1 to 2 pages of living will. So living will is another way to call advanced healthcare directive. So advanced healthcare directive and living will refer to the same thing. It just talks about, end of life situation. Do you want to pull the plug or not kind of thing, right? So those 1 to 2 page of living will forms generally are not honored by healthcare providers because of liability issues. They're worried that doctors are worried if they pull the plug, then are people going to come after them, right, for liability issues. So their doctors are all very wary of that. So they need to see the specific provision that protects them from being sued. And so you want to make sure your document, so in addition to the ones, those really ideally the best scenario is for you to have 3 components. One is the living will, the advanced healthcare directive with the liability provisions in there. And also healthcare power of attorney that allows you to make the decision for your parents' healthcare, and also a HIPAA authorization as a standalone document. Because of the HIPAA laws that just changed a few years ago, the HIPAA authorization actually has to be a standalone document, otherwise it won't be honored. And so those 3 components, and it is not enough to just say, I do not want artificial procedures. You have to define that. So what does it mean? What does it mean to be terminal? And we know, dealing with the hospitals, it's endless. They have a multitude of procedures they can do on you, right? So it's where's the end? And so then the conversation becomes to what extent, right? How much dignity do we want to preserve, right? If I can be physically saved, but I cannot recognize my family members anymore, then do I still want to be on life support? Then if not, then you want to document that, right? So you want to say that or share that, of course, talk to your parents about that. But all of these, you want to just make sure they are in writing, okay? And, digital copies, make sure you have that on your phone. And every state has the registry with the state. In California, you can register with Secretary of State. Every state has it. So you can register your mom and dad's advanced healthcare directive at the state. So if they're in the hospital personnel can just pull that out from the state record. So that's a very easy thing to do. It's only $10 to register. So why not? So we talked about this. You definitely want to make sure your healthcare directive is effective. So rule number 4, and I know it's 5:46, so I better hurry up. Rule number 4 is we want to make sure it's you avoid probate. So what is probate? Probate is the state's plan for you. If your mom and dad don't have any estate plan, the state has a plan for mom and dad. That is called probate. Probate is a court process. Basically, you as the daughter would have to go to court. And, probate is for people after death, and then conservatorship is for people when they're still alive. So if mom is in the hospital, they're incapacitated, then you as a daughter have to go through conservatorship. And probate is for if mom and dad is no longer here, then you still have to go through court to get a hold of your asset. As I mentioned previously, it's very, very expensive. It's easily 20,000, and we've seen like 20 to 30,000 easily, and you end up stuck in court for 12 to 16 months easily. It's a mental drain, and which can easily be avoided if you have the proper documents in place. And so, of course, one very effective way to avoid probate is to put it in a revocable living trust. And the revocable living trust, here's the thing about trusts. You can, and I actually literally just did somebody I think it was Dave Ramsey's, somebody had Dave Ramsey or Susie Owen's trust. They came to me, I'm like, oh great, and guess what? Just think of the trust as a treasure box, right? And turned out that trust or the treasure box doesn't have anything in it. So think of it this way, this treasure box here, this treasure box can only protect the money if it actually has money in it, right? If all the gold coins are outside of the treasure box, then the treasure box is empty. Then you have to still go through probate court for the coins that are outside of the treasure box. That's just kind of an illustration of how important it is to make sure your trust is properly funded. And properly funded is actually a legal term. It just means that you have to make sure everything is properly titled, right? So there are different ways to retitle them, and unfortunately the LegalZoom type of trusts are just not going to tell you how to title those assets. So just be aware of that. Another key component of keeping track of what mom and dad owns is, right now, at least in California, and every state is different, and this can be a homework for you. Find out how much is in the unclaimed property division in your state. I bet you will be shocked to find out the number. And this is because in California it's 9.3 billion. And this is because when mom and dad passed away, the children don't know what mom and dad owned. And if they don't know what mom and dad owned, after 7 years, the assets that mom and dad worked so hard during their lifetime to earn go to the government. And it's a pain to try to get it out of the government. So you really want to make sure you have a clear inventory of what mom and dad own, and you can know where to locate them if need be. Next one is your home. So the key thing here is, so somebody heard, if you just kind of Google online and you're like, oh, I learned that I have this extra pot of money, I can try to, apply for Medi-Cal, for Medicaid, for mom and dad. And one of the rules is that I have to, there's a resource limit of under, 2,000, and I have to have income of under, however much amount it is in your state. So I should just sell the home. I'll just spend it all. Please don't do that without talking to an attorney. It's very, very important. For your home. Every state has a homestead provision And luckily in California, if it's your primary residence, the home is exempt. So you can own your primary home and still qualify for Medi-Cal long-term care and have the government pay for your mom and dad's medical expenses and long-term care expenses. So that's just an example. Do not just sell or do whatever with your house without talking to an attorney. It could be that you could still own your home without any impact. And so there are actually specific requirements, like for example, just to give you a few, you need to have the intent to remain in the home, or there has to be another, like if mom and dad are married, then the spouse has to continue living in the home. Just some examples of how your primary home could be a very valuable asset that you don't have to worry about. The next thing is to avoid gifts. I just mentioned that one strategy sometimes is for people to spend down, but then people read these things online and they start giving away assets. The most important thing for you to know is the government actually imposes a penalty if you gift, if we're trying to help mom and dad get additional financial resources from the government and to have the government pay for mom and dad's long-term care in a good, high quality facility or whatnot, or to get that extra money to have the in-home support. In California, the look back period is 30 months from the time of the gift. So from the time when you start giving that gift, 30 months from that date, then you're good. Then you're free of any penalty when you apply for government benefits. In other states, in general, in states that implement the DRA, which is the Deficit Reduction Act of 2005, the rule is 60 months, so 5 years. There's a 5-year look back period. That just means at the time when you apply for additional government benefits, whether it's VA benefits or whatnot, whatever benefits you are applying for, they're going to look at 5 years from the date of your application and see if mom and dad gifted away anything. If they did, they are going to count that gift as part of your application, and that could disqualify mom and dad's benefit. And so that's really, really important for you to know. Now, I know we have only limited time here, so I think the takeaway is to just know not to gift away anything without talking to an attorney. And so the next thing is rule number 7 is you want to discuss whether a family caregiving agreement may help your family. So let me explain what that means. So here's the thing, mom and dad have worked really hard during their lifetime and they have their assets, right? And oftentimes, if they have to spend all of their money in medical care, there's nothing left for the family. But one really creative way around, under the rules of the laws is to create a family caregiving agreement between mom and you. If you as the daughter are already taking care of mom and dad anyways, then we could capture that in the legal writing and then basically you just capture that in writing and say you're giving care for mom and dad for however many hours, and mom and dad agrees to pay you however much compensation. Now they don't really have to pay you. It's just a legal strategy so that you can capture that money in there, so that the government so that you could keep that money within the family without it going anywhere or disqualifying you for anything. Okay, and so in my handout, I'll list out what to include in the family caregiving agreement. The next thing is to consider long-term care insurance. I'll leave this for insurance professionals, but just know that it's a very complicated process, right? And there's so many moving parts. You definitely want to talk to people, about insurance, have that insurance advocate who you can talk to. And of course, rule number 9 is encourage your parents to create a notebook with all necessary information so you can know at least how to access them. So you have a clue. And I'll give you just one example, I guess, from my case study, one of my cases. So one of the things that drains people's assets after after people pass away is trying to locate the asset. I just had to deal with the trust administration recently, and we spent about like $10,000 just trying to figure out what assets are included in the trust because it was not included, and they did have a trust, right? And so my point is, so we want to make sure that you know where those assets are, so you can easily track them. You know where mom and dad's legal documents are, so you can know how to access them if need be. Rule number 10 is, of course, be pragmatic about living arrangements. Now, we all want to stay at home, right? We want to, mom and dad, we want to just, be at home. The problem is sometimes we just cannot afford it. And, the goal really is to be as independent as possible with a high quality of life as possible. And sometimes a move to an assisted living or dependent or living community can be affordable and provides greater, quality of life. And that's an expertise of Karen and Christine. And so I'll leave that portion to them. But from my perspective, as a lawyer, I get it. I talk to family members. I get it that you want mom and dad to stay at home, and mom and dad just don't want to move. But sometimes we have to kind of balance everything out. And sometimes it may make sense to be in a nursing home care, or that because that's the only place where you can get around the clock skilled care. And so it's so important to talk to professionals in the community so you can know the best resources for that. And while mom and dad are open to it, maybe, see which organizations are more reputable. You can ask the advisors what's more reputable and examine the different ways. How can we protect mom and dad at home to prevent them from falling, and things like that. And have an emergency response system. Like you may want to put like an emergency contact info on the refrigerator, or you have to do things like that, right? And just be aware of all the social services that's available to you and the care management resources that are available to you. And Daughterhood is just such an amazing organization that it pulls all the resources together so you can get it all in one place, right? And now the last thing is the bonus rule for you. We talk about the legal component of those documents and all these things you need to do. But really, at the end of the day, it's about, mom and dad's insights and values and their legacy, right? How do they want you to remember of them? What are those assets that are so valuable? And, when we talk about family assets, it's not just the financial and legal. It's so much more about the intellectual, emotional, and spiritual component that we want to capture as much as possible when they can. I mean, you don't want the last memory of them to be only the time when they cannot even speak. Right? So we want to, while we can, if we can, to really capture as much of that as possible for ourselves, for our children, if we have any. And the next thing is, of course, one size fits all planning really leaves your family at risk. That's why it's so important to have a trusted advisor who can be there for your family and to just kind of help you navigate the system, who's not going to just sell you a document, but actually looking at the big picture and assess and help you make the right decision for your family, right? So with that, I think I'm going to open up for questions. Right now, I think it's 5:59, so I think it's about time for us to take some questions.
Amy, that was so good. The one that I especially took away was about that I wasn't familiar with, was about the family caregiver document, to putting that in place as a way of just having it be a legal document, of just a way to not necessarily, it's just a document to keep in place so that way it stays within the family.
Yeah.
It's just basically like a legal road to take to be able to keep those assets.
Yeah, it's a wonderful tool that we utilize a lot when we do long-term care planning. There are, of course, some pros and cons, and that's, again, a very family by family situation. Of course, there are some tax consequences with that, but it may make sense in some situations. So, but it's a wonderful tool. Yeah.
Okay, well, I kept some notes of some of the questions that came in during your presentation. So Mary Ellen asked if we can get a file with a PowerPoint presentation for future reference. And which I'm guessing you could, hopefully, Amy, you could
Yeah.
share with us so we could share it with the group.
Yeah, that's fine. Yeah,
Perfect.
I'll send it to you and you can share with the group. Yeah.
Perfect. And we're recording the presentation tonight too, so we'll make sure to include the file plus the video recording so you all can reference it. Um, and then we had a few questions from Sarah N. One of her questions does power of attorney docs expire?
So it expires when you die. So power of attorney is only valid when you're alive. It also, when the grantor, when the principal or the holder of the power is mom and dad, when they're alive, then they have that power. If they lose capacity, then you as the agent, you can exercise your power under that power of attorney. Yeah, so it expires after a person passes away. You can also revoke it. So if they revoke it, then that also expires.
Okay, very good. And then Sarah's other question was, do you need one for every account?
No. So you can have a general durable power of attorney for all the assets, all the financial assets. Now, every bank is different. And here's the reason why pre-planning is so important. Sometimes the specific banks, like I know BOA and Chase do, they require their own specific power of attorneys. And it just is easier while you can to just fill out their specific power of attorney for that bank, so you don't have to argue with them. Of course, the power of attorney, the general power of attorney that you prepare with an attorney's office, you can use that for each and every bank, but just in case if they have their own specific form, you want to fill out the specific forms. And then also it is a good idea if you know what assets, like with real property specifically, you don't need to list all the bank accounts on your power of attorney. No, you don't want to do that because you don't want people to know, right? But with the real property, you definitely want to have the legal description on there.
Good. Okay. And then Sarah's other question, her last question here is, would you be held responsible if they, I'm guessing she means like the parent or the loved one, would you be held responsible if they make decisions while they still have some capacity?
Well, so there are two types of powers of attorneys, right? So one is a springing power of attorney and the other one is the durable power of attorney. So springing is only when you as the agent don't actually have the power to do anything for mom and dad unless they lose capacity, right? And so you have to look, there are specific provisions in the durable power of attorney that says when you can start acting for mom and dad. If it's a durable power of attorney, say it's immediately effective. If it actually says it is immediately effective, then yes, you as the agent can immediately take actions for mom and dad right away without any, or consequences or whatnot, because mom and dad agreed for you to take actions for them immediately. The other scenario is if it's a springing power of attorney, that means there are certain conditions that have to be met before you can start doing things for them. Usually it's like upon 2 licensed physicians signing and saying that mom has lost capacity, then in that situation, then you as the agent can take that power of attorney along with the 2 physicians letter, and then that's a valid document, and then you can act. Yeah.
Perfect. Okay, Sarah, if that answers your questions, if you still have questions around that, please let us know and we'll continue the conversation with Amy. Okay, and then I actually had a question in regards to the slide which had rule number 2, which was a special long-term care durable power of attorney. Is the special long-term care durable power of attorney, is that different than a regular POA?
Yes. So
So the general durable power of attorney, yeah, a general durable power of attorney, it generally doesn't give you that authority to apply for government benefits and do special things specific to long-term care, such as creating irrevocable trust, such as gifting to yourself, such as signing admissions papers. These are extra powers to be included in a power of attorney. Now, in general, the general, when you go to typical estate planning, generally we don't include the long-term care provisions unless mom and dad are really needing that. It's just because that power is a very it's a huge power, right? To be able to do that for somebody. And so we only add in that power when you feel like mom and dad really might need that in the imminent future.
Okay, that's good.
And I want to share something here. I forgot to mention. Oh, so yeah, hold on one second. So I just mentioned the probate, and then the long-term insurance, and then the bonus, and one size fit all. You really want to have a customized planning for mom and dad. And then I have a golden ticket for everybody here. So you'll get this later in the PDF, but for those of you who are here, and if you want to talk to me privately, I know we only have limited time, but if you want to schedule a time with me, you can on my website. I typically charge for my initial consultation, but I have a coupon code, or I guess a code you can type in when you schedule on my online scheduler. Then that'll give you a complimentary session. So that's what the golden ticket is about. So you'll get that. You'll get that later.
Amy, thank you so much. That's very kind. I mean, it's very expensive to talk to attorneys. So thank you for gifting, for blessing the Daughterhood community with that. That's very kind of you.
Oh yeah, my pleasure. My pleasure.
Good. And then Karen asked, what is the average cost of trust that would include POA or will, etc.? It will be different in California than in other states, but at least have an idea or a range. So for example, if you have less than 30,000, is it worth doing? What's the least and most on average? Most people think they don't need legal documents because they aren't millionaires.
Right. I'm so glad you asked that question. Yeah, that's a great question. And so the trust, the reason why you need trust, one of the main reasons is to avoid probate, right? So the threshold for going to probate is, in California, it's $166,000, 250. I know very exact amounts. But in general, in most states, it's about $150,000 or so. And if you have, so you can think if mom and dad have more than $150,000, and if you own a home, if the home is more than $50,000 in fair market value, I know that's insane. So if you own a home, then you pretty much have to go through probate court. So if you have a home, then having a trust is a really good idea. So you don't have to end up in probate court. Now the trust, it's not just about avoiding probate. It's also so much more about as we mentioned, the power of attorney, making sure people can honor your wishes, and then the cost of the trust in general. I would say, it ranges. I think the range is probably somewhere between 2,000 to 8,000 or so, somewhere that's kind of like the big range, but it depends on what you want to do, right? Of course, it depends on how much asset you have, how comprehensive you want it to be. There are definitely asset protection strategies that we can build into the trust. If mom and dad want to capture as much asset within the family and protect the children to give to you, and if you were ever to be subject to a lawsuit or creditor claim or divorce, and they want to protect this asset for you so it would never ever be taken away by other people, then that's a layer of asset protection that we can easily add in mom and dad's trust. And so as you can see, I'm just we only have limited time here, but there are so many creative legal strategies that we can implement to help capture as much asset as possible for not just mom and dad's care, but also for the later generations. Yeah, and it's so important to have that done right, so that you don't end up being one of those people who have a trust but still having to go to court.
Yeah, that's a great point.
Mhm.
Okay, and then Mindy asks, what happens once the POA expires? How do you access the accounts?
If the POA expires, then it depends on if you have a trust or not. If you have a trust and you're the trustee of the trust, and if the account is already, so that's another reason to set up a trust, right? And if the bank account is already in the trust, then you as the trustee can immediately access the bank account. And honestly, trusts are way better than a power of attorney if you can do that, if you have the resources to do that, simply because banks honor trust better than power of attorney, because power of attorney is really easy to set up, right? You can download some form, whatever form, like, and you can just sign it, and you can just show it to the bank and then say, hey, I have the power of attorney. Anybody can do that. It's just how effective it is, right? And whether they include the provisions or not. But trust is harder to set up, right? Like you have to go through all these hoops. And so banks in general, they honor trust documents way better. So you as the trustee, if you're the trustee of mom and dad's trust, that gives you more power and more flexibility and immediate access to the account. And in fact, you can even help mom and dad when they're alongside with them, right? Because if you're the co-trustee with mom and dad, you can already be making decisions for them without having to worry about courts later on.
That's right. Okay, so to summarize, because the POA expires whenever they pass away, so that's the benefit of having a trust, because even if they pass away and that POA expires, if you are a trustee, then you can continue to do the work and do the things that you need to do in order to manage those accounts. Is that correct?
That is correct.
Okay. Yeah. So Mindy, I hope that answers your question. If you have any more questions around that, please let us know in the chat. Okay, and then, so I think that was it for questions. I just wanted to put out there was a couple of comments. Jan wrote here that FYI in Texas, probate is not very expensive, so contact a Texas attorney for specifics if you live there or your loved one lives there. And then Deborah H mentioned that Medic Alert Foundation allows you to upload legal docs, so they will be available to you in one secure, safe place. That's with the purchase of a Medic Alert bracelet. So that's very good information to know. Good.
Great, yeah, and so I guess some final points to wrap up is, every state is different, and definitely consult with an attorney. And I can, give you some names if you need the specific attorneys in that state. So definitely consult with the attorney in your state. To make sure you plan it out, and check with your state, make sure to register your healthcare documents. And as the daughter or as a caregiver, know where those documents are, save them on your phone or store them on your computer. And while mom and dad are open to it, talk to them about it, have the legal documentation in place. Make sure the important provisions are included, which you'll have on the PDF when Christine sent it out later. And to the accessibility is important, and also just talking to them about their wishes and desires, so you can make the best decisions for them if need be, and help them maintain that quality of life and dignity as well.
Yeah, that's great. And one more, Amy, Mindy just asked another question. She says, is it best to consult with an elder care attorney versus any lawyer?
Oh, I'm so glad you asked that question. That's a great question. And so it's very, very important for you to look for somebody who has experience with elder law and estate planning. So somebody who practices exclusively in estate planning and elder law planning are going to know the nuance in all the different things that go into place. And they tend to also know the consequences to the multiple generations. And NAILA is a wonderful organization. You know, you can easily go on there and look for an attorney that's in your region. And so it's just, you know, the Medicaid rule can be so complicated. You definitely want to work with somebody that specializes in that. Yeah, and look for the credentials. You know, what experiences do they have? You know, what organizations do they belong to? Things like that. It's very important. And I always tell people, you know, do right by mom and dad, right? Pick the right attorney. And if you don't know who to pick, you know, talk to your advisors. Karen and Christine talk to people in Daughterhood. They'll guide you to the right direction.
That's perfect. Oh my gosh, it's always a good thing when you can get an attorney to speak to you for an hour and just answer questions. It's gold because, you know, it's not cheap. So we're so thankful, Amy, and thank you for that gift again. So we'll make sure that we'll provide the registrants that are here we'll make sure that they get your PDF and you know, that coupon code that you're going to give us so that they can consult with you. So that's very kind of you. We're very grateful for that.
You are so welcome. And I am just so blessed. I wish this organization was, you know, like I was talking to a friend of mine and we're like, oh, I wish it was here when I had to take care of my mom and dad, right? So what a blessing. What a blessing.
Thank you. Thank you so much.
Thank you so much, everybody. If you have any other questions, just reach out to me privately and I'm happy to help. Thank you. Bye.
Bye. Thank you, Amy.
You're so welcome.